You're listening to Talkline with Zev Brenner, America's premier Jewish broadcast on the air since 1981.
And now, here's your host.
Welcome back to the program. Zev Brenner. Supreme Court ruling today could have implications for yeshiva parents, good implications for that. To Ohio we go. With us right now is Rabbi Yitz Frank. He is director of Agudath Israel of Ohio, also a lobbyist for the Agudath. So thank you for joining us.
Zev, thanks for having me.
Now, the decision came down in Carson versus Makin, which the Supreme Court heard. Tell us about the decision, then we'll look about some of the factors, how it even got into the Supreme Court.
Yeah, so the case was decided today. An opinion issued by Chief Justice Roberts really answered an important question that Agudath and our allies around the country have been trying to get addressed by the court for decades. And mainly that revolves around that when there's a state constitution or a state law that maybe doesn't directly discriminate against a religious institution like a school or a preschool or some other kind of program, and limits participation in those programs to only sectarian providers, is that a violation of the free exercise clause? Does that make it so that religious communities or families are not able to access what is otherwise a pretty neutral government benefit? And we are really, really pleased by the court's opinion today.
So what does this mean for, let's say, yeshiva parents in New York or Ohio or other parts of the country? Does it have different implications no matter where you reside?
Yeah, so to be very clear, right, this opinion came out today. There'll be a lot of legal scholars that are going to analyze this, not just today, but over the next few weeks, and discussion about what the implications are, right? But some of the ideas that could have an implication immediately are there's conversations. There's been a conversation in Congress for the past couple of years about a universal pre-K program. For example, New York has a very large UPK program. Well, there have been issues in the past about, can religious providers participate? If religious providers can participate, are they allowed to give a religious flavor in their instruction? Can they provide religious content in their instruction? The ruling today could absolutely have an impact on that. Again, it's not immediately clear whether it will or not, but those are the types of examples that could be impacted by this. Another point is, and again, this won't have an immediate impact, but we have been working in states for many, many years to pass school choice programs. Well, issues have been raised in different states, including New York, by the way. If you recall, 7 or 8 years ago, there was a very serious push to enact a child tax credit, or not a child tax credit, I'm sorry, a school choice, a scholarship tax credit. And that would have had unfortunately, we didn't get it done. But at the time, there was a very, very serious push. The Senate was on board. The governor seemed to be all gung-ho about it. And some of the issues that were raised that really inhibited that lobbying effort is the Blaine Amendment in the New York Constitution. Now, our opinion was that that the Blaine Amendment would not have made a difference there. But Blaine amendments basically prohibit, in many cases, religious institutions from participating in what's normally a neutral government program. Well, the opinion that was issued today says, no, you can't say that just because a school is religious, therefore they can't participate in a school choice program. That would be a violation of our First Amendment rights. So again, there are many states that have those types of provisions. It makes it more possible to enact a law that gives parents choices in education.
No, certainly this is a positive development. As you said, it may take a number of weeks or months before to sort exactly what it is, but it's something good. Question is, how far is it going to go? And question is, how far can it be interpreted? And that's going to be spoken about, worked on over the next couple of weeks or a few weeks or beyond.
Yeah, absolutely. And again, my expectation, and you can sort of, if you read the opinion, if you want some good bedtime reading, I'd encourage everyone to read the opinion and read the dissent as well. And you'll sort of get an idea of what these two factions in the court were arguing over. The dissent who did not want who did not agree with, obviously, the majority. One of the things they pointed out was exactly what you just said. if we rule this way, well, all of a sudden, will states be required to fund religious schools, right? That was something that the dissent pointed out. It's something they were thinking. These are very serious, very smart judges. Now, obviously, they were trying to raise that argument to undermine the majority's opinion. The majority expressly pointed out that this ruling does not mean that states will be required to do that. But obviously, this is a conversation that religious and legal scholars may have as a result of this opinion. Again, that doesn't mean that we will get there, but it's certainly an important step as we work to make sure that our community in New York, in New Jersey, around the country is able to participate fully in all of the benefits and important institutions in our country, while educating our children in the institutions that we choose.
But I think there are also two different aspects. That one aspect is can government fund religious schools, which is question A. Question B is, can government and federal programs fund non-religious aspects of a Jewish school or Catholic school or religious school? And that's a second issue. And lots of times where funding has been for lunches and other activities were not religious. And that's how they've gotten around it. But I think a lot more has to be done, because a lot of parents are choking under tuition. It's a double taxation, because if you went to public school, you'd be getting about $25,000 value in New York or more. I don't know what it is in Ohio. So you're not getting that, and you're paying double taxation, and you're saving the state money, because in New York, can you imagine 50,000 yeshiva kids, Catholic school kids, other parochial schools going to public school? It would ruin the system. They couldn't even handle it. So we're doing them a favor by having 50,000 kids there, but there has to be some way of balancing out where there should be some more benefit to parochial school parents.
Right. Well, and part of this is, right, this is a bigger issue. Obviously, of course, Agudath is in this fight for that reason, right? But this is a broader statement that the court is making. We've been arguing for a long time that the First Amendment, right, the free exercise of religion, is an important value, not just to our community, but it's an important value for our country. That's how our country was founded, right? It is a place that is supposed to be hospitable to people of faith, from, no matter what it is. And this was a statement by the court saying that, yes, the free exercise of religion goes farther than what was previously understood, and really took a shot at some really, I think, attempts that were made in bad faith over the years and centuries that really inhibited people of faith from participating in life to the fullest extent.
Rabbi Frank, tell us, how long did this whole case take, and it went through the courts? I'm referring to Carson versus Makin. I'm curious to know who they are, but give us the process.
Yeah, so I don't remember the exact dates, but basically here are the facts of the case. Maine is a very rural state. They have many school districts don't have their own high schools. And so what they do is they have a program that says, okay, if we don't have a high school, parents, you can go and find another school, hopefully nearby, and we'll pay for it. Well, but they had a rule. The state law basically said, really, they changed the law in 1981 to not allow sectarian religious schools, in other words, from participating. And this made its way to the courts. The family's name was Carson. That's why that is the name of the case. And there's a whole set of facts, and you can read the opinion, but basically their kids were denied from participating in the school that they wanted. They challenged the law in court. What eventually happened was the First Circuit Court of Appeals agreed with the state of Maine and said, yeah, this is constitutional. And one of the things that they said was that there's a case that, this is sort of important history, so it's not a real digression here. There was a case that the Supreme Court ruled on 2 years ago called Espinoza. Very similar circumstances to this case. But in that case, the state of Montana had a tax credit scholarship program that basically said, we'll allow tax credit scholarships to fund scholarships at sectarian schools, but not non-sectarian. At non-sectarian schools, but not sectarian schools. Well, parents challenged that, and the Supreme Court basically said, you cannot go and just discriminate against a family choosing a school simply because it's religious. Okay, Now, what the state of Maine did, they made a few points. One of the points they made is, hey, we agree that we're not discriminating against the school because it's religious, but because the education that it is providing has a religious connotation to it or religious flavor to that. We are saying that we are not going to fund that. So in other words, they're trying to make a distinction between a school whose status is religious, it's religious, but the education may be almost completely secular, and a school who is not just religious, but also provides a degree of religious education or religious flavor or values, however they define that. And essentially the Supreme Court took a couple years to get to the Supreme Court's attention. They granted a cert, which is basically saying, yes, this is an important case. We want to rule on this ourselves. And ultimately that decision was handed down today. And the ripple effects will be felt for years to come.
No, true. It's a marvelous step. And when did the Agudath get involved in this case?
We were watching it at the appellate level. I don't recall whether we filed a amicus or got involved at the appellate level. We certainly got involved at the Supreme Court level, both asking them to take the case, which is a process in and of itself, and then submitting an amicus brief to sort of support the position that we felt the court should take. But we really got involved many years before that. This case, again, the precedent for this case was based on the case I referred to earlier in Montana called Espinoza. We did the same thing in that case. That ruling came down 2 years ago. And that case itself was really built off of another case called Trinity Lutheran. I think you might have even interviewed someone on this, which was several years before that. And so you see how these cases keep building up on each other. In fact, in the dissent, Justice Sotomayor, who was in the minority in this case, basically said, hey, I warned the court 5 years ago not to go down this route with Trinity Lutheran, which is, by the way, a case in Missouri where Missouri had a program that they would give ground up rubber tires to put by playgrounds so that kids wouldn't get injured. And the attorney general at the time basically said, but if it's a religious school, in that case a church, they can't participate, even though this had nothing to do with religion. It was just a playground outside for kids to play in, but for some reason it's not a problem if their knees got skinned, right? And so this court then said that no, that was, I believe, a 7-2 case. I think Justice I don't remember exactly, but there were some of the justices in the minority today were in the majority in that case. But Justice Sotomayor said, I warned you not to go down this path, and this is where we ended up, and we agree with her. That's why we were involved then, and that's why we're involved now.
Case, when it strikes me, if the playground was operating in a legal fashion or did things that violated federal code, they'd be down on them without even thinking about it. So if that's the case, then they should make sure they have the proper equipment. So I can understand why that case was ruled the way it was. It just doesn't make any sense. It's talking about safety, talking about other features, and you can't have it both ways. But anyway, it's all going to play out. And what else is on the horizon that we should, anything else on the pipeline that may be affecting tuition that you know about?
Well, I am mostly, my legislative activities are mostly focused on Ohio. My guess is that's not where the majority of your listeners are yet. So I don't want to bore them with too many details, but we're obviously working in legislatures around the country, including New York, to do whatever we possibly can. Different opportunities are presented, sometimes based on who's in the legislature, sometimes the time calls for it. I don't know exactly. I don't know if we finalized our legislative agenda in New York for this coming year. I'm sure Rabbi Silver and Rabbi Zubel could fill you in on that whenever it's ready, but it is always on our agenda, focused on that issue. How we get there, different opportunities are presented, and we take them as we can.
And I want to thank you for Rabbi Yitz Frank, the director of Agudath Israel of Ohio. He's a lobbyist. He, as you see, has his finger on his pulse and trying to get tuition tax relief for parents. And today's decision in Carson versus Makin certainly will help yeshiva parents. How much? As you heard, the jury is still out, but it certainly is a good step in that direction. So thank you for being part of our show.
Thank you, Zev.
Thanks for listening.
For continuous Jewish programs, TalklineNetwork.com,
or our 24-hour-a-day listen line at 641-741-0389. For past shows, you can find us on iTunes, Spotify, Amazon, YouTube, Instagram, and all major podcast platforms, or jewishpodcast.org. Thanks for listening to the TalklineNetwork.com.